Look, I normally don't do this, but we have 3 hours, and there's 3 huge subjects I want to cover. One is the trial in Manhattan. The other is what the International Criminal Court did. And then the last is Biden's speech at Morehouse College. And there'll be other issues, too, but these are 3 big deals. 3 big deals. And I want to start with the Trump trial. On March 31st of this year, really not that long ago, what is that, 6 weeks ago, give or take, Mr. Producer? I had Brad Smith on Life, Liberty, and Levin. And, you know, I do these long-form interviews, and we talked about the allegations and the charges against President Trump, and we talked about federal law. And he made it abundantly clear that this non-disclosure agreement did not violate federal law. That is federal election law. He's a former chairman of the FEC. It's probably due to that interview, because this judge knows what he's going to say, that this judge determined that Bradley Smith is not going to testify as an expert witness on behalf of Trump. I have never seen one abomination after another like this. I have never seen anything like this. Seriously, folks. This judge is barely knowledgeable about the law in the state of New York, let alone federal campaign law, which can be very complex. Apparently, he's doing everything he can to undermine Robert Costello's testimony today, so Costello can't tell the story of what took place as the prosecution keeps objecting, and interrupting. The judge should have put an end to that, but he didn't. This guy is so in the tank. He's like a mob judge. Except I don't want to really libel the mob. The guy's a punk. And so we went back, and we found part of the audio of the March 31 interview with Bradley Smith, the first segment. I have the full text here. Honestly, we shared this with everybody at Fox as well to remind them that we know what Bradley Smith's going to say. Rather than speculate, rather than lawyers talking to lawyers, lawyers talking to non-lawyers, non-lawyers talking to non-lawyers about what he might say, and so he said it. He said it. Right there. For millions to hear, and millions did hear. So let's begin with this, with Bradley Smith, the former chairman of the Federal Election Commission, not only an expert on federal election law, but he still teaches it today as a professor. Cut 29, go.
The Alvin Bragg case rests on an effort to federalize state law to turn a misdemeanor, if there is one, into a felony based on a bizarre interpretation of a violation of our federal finance laws, federal campaign laws, one that was already tried, but interestingly enough, by Jack Smith with John Edwards and fell flat. Do you want to explain to the American people the core of what Alvin Bragg's attempt is with respect to federal election law?
Sure. So to upgrade what would be a very routine misdemeanor in New York to a felony, the DA has to show that this misreporting, as he alleges, was done in order to conceal a crime. The crime, he says, that was being concealed was a violation of the Federal Election Campaign Act. And what he says that was that by paying money to Stormy Daniels for her silence, that amounted to a campaign expenditure and therefore was not properly reported under federal law, and that jacks the whole state claim up to a felony. Now, the problem with that is that federal law does not say that anything that you think might help you win an election is a campaign expense. Rather, it's an objective test in which things like polling, paying for staff, paying for headquarters, paying for advertisements and so on, those are campaign expenses. And the law, in fact, specifically prohibits someone from using campaign expenses or making campaign expenses for personal use. That is, to pay, things that might help you, like good-looking clothes or plastic surgery or a good-looking haircut or a nice relaxing vacation so you're fresh on the trail, country club memberships you can entertain, or settling nuisance business suits so that they're not an issue in the campaign. Those are all viewed as personal expenses, and they're not something you can pay with campaign expenses. So I think that's the problem that the DA have. He's trying to allege that these campaign expenses, these payments to Stormy Daniels were campaign expenses. And I think quite clearly they exist from an obligation independent of Mr. Trump's campaign for president. You mentioned the Edwards case. We'll go back to Edwards. This was tried, a similar case with John Edwards. People remember him, ran for president back in the early 2000s. Edwards had supporters who spent money to support and keep quiet a mistress whom he had gotten pregnant. And that went to trial. The jury ended up either hung or acquitting Edwards on a number of counts that was, finding that was not an offense under federal campaign finance law.
And live now, this is what the judge does not want the jury to hear. The judge is conspiring with the prosecution to keep the ambiguity of some federal offense sort of hanging over the trial as a dark cloud. And he doesn't want it defined because if it's defined, it becomes clear it's inapplicable. There's nothing there. And, of course, if you don't have the federal offense, which requires intent, by the way, then you don't resuscitate the state law, which has expired, let alone increase it from a misdemeanor to a felony. Now, we're unable to find the remaining part of the interview, so I want to read this to you. So I go on, but the theory is the same theory, which is that if anything is done that may positively impact your campaign as opposed to negatively impacting your campaign, and let's say it's an illegal, unreported corporate contribution, or in the case of Edwards, just an illegal contribution. And this is why people are saying that this is a preposterous case. It's sort of a maze they have to go through and follow. It's why the U.S. Attorney's Office wanted nothing to do with it. It's why the prior district attorney wanted nothing to do with it. Bragg dusts it off and he says, no, even though I'm a local DA, I'm going to pass judgment on federal campaign laws, which he has no jurisdiction to do. I'm going to assert that this non-disclosure agreement that was provided, but it is in the wrong category as a legal expense, or maybe it should have been a business expense. And I'm going to assert all of that was done in violation of federal campaign law in order to create a positive campaign image. Is that about right? So, ladies and gentlemen, I'm playing this so you know why the judge does not want Bradley Smith, his testimony, and also to point out one other thing. You watch me on Fox, you listen to me on radio and on Blaze, because we're way, way, way ahead of the curve on this stuff. And Bradley Smith answers, yeah. I mean, that's his theory. He says, and by the way, Mark, also, the Federal Election Commission chose not to act on this. That is, on the Trump issue. And they, under the statute, are supposed to be the primary interpreter of federal campaign law. And here's the thing about this, is that had Trump used campaign expenses to pay off Stormy Daniels and file this as a report, you can pretty much bet your house that people on the left would be coming after him for misappropriating campaign funds to pay personal expenses. In other words, ladies and gentlemen, the non-disclosure agreement was a personal expense. It wasn't an expense for the campaign. It wasn't a campaign expense. And that's how the FEC considered it. A personal expense categorized as a legal expense by the corporation, all perfectly legal, nothing triggering federal campaign laws, period. And he went on, did Brad Smith. And in fact, even now, people on the left in the last week or so have released a spate of columns and commentary arguing that Trump cannot use campaign funds to pay his judgment against him. In another, I think, kind of preposterous suit. And that's this alleged civil fraud suit with $450 million judgment or whatever it was. So you have a sense that they were going to get him coming or going. If he paid for it, that is the non-disclosure agreement, with campaign money, they would say it was personal use. That is misuse of campaign funds, a felony. If he doesn't pay for it with campaign money, they want to say, hey, you didn't properly pay for it with campaign money and report it as a campaign expense. And you can't have it both ways. And he says, and I think the DA's theory ultimately is going to crash. He may even win a trial there in New York and everything, but eventually I don't see it standing. But in the case of John Edwards, It was even more direct, even though it wasn't a violation of law. That is, donors did raise the money and provided to protect Edwards from the negative publicity. And in that case, and in this case, rather, Trump, we have a state law, a reporting issue that I would argue isn't even a misdemeanor. And then you have the DA going into federal law where he has no jurisdiction. You just said the FEC that oversees it says no violation. The U.S. attorney doesn't want anything to do with the prior DA. And he's twisting the law. He's twisting it to try and apply it to Trump. So it's even, in my view, worse than the John Edwards case. Brad Smith. Well, I think it is. And it's worse. And in another way, which is in the Edwards case, it's entirely clear that they were paying his supporters. They were paying this woman in order to protect the political viability of Edwards. Whereas in the case of Donald Trump, well, that was probably a consideration, or at least may have been a consideration. He also had a number of other considerations to protect himself, his wife, his children, commercial interests, and so on. So, yeah, I just don't think that there's any real basis for alleging that this is a campaign expenditure. I always put it to people, when you contribute money to a campaign, is this what you expected to be spent on? And the answer is no. This was a personal expense. Now, by the way, personally means corporate, too. By personally means it's not a campaign expense. We're with Bradley Smith, Capital University law professor, former chairman of the Federal Election Commission. He founded the Institute for Free Speech, I say. Non-disclosure agreements. HR departments enter into those all the time, every day. Media corporations that are calling this hush money. I noticed NBC has entered into non-disclosure agreements. Most non-disclosure agreements are secret, so we didn't even know. They entered into my CNETs entered into them. All kinds of people have entered into them. So, and by the way, members of Congress, as my wife reminded me, in 2017 entered into a whole ton of them. So is it the effort here by the media and others, the Biden campaign, to try and turn this into some kind of a treacherous, evil event? He's trying to cover it up with hush money, and then he uses corporate money, and then he uses it in violation of federal campaign laws. Isn't this all bogus? Bradley Smith, the probably number one expert in America on the federal campaign law, responds, yes. There's a lot of smoke. And as you point out, Mark, hush money is just a pejorative term. You can call lots of settlements hush money, or you could call them settlements and non-disclosure agreements, and usually they're called the latter. And in this particular case, for example, I draw the comparison. They're businessmen. Like Trump will always have a lot of lawsuits going against his various businesses, and he may, in particular point, tell his local counsel, say, look, I want you to settle this lawsuit. The guy says, no, it's a good case. He says, now just sell it because I don't want it distracting my campaign. He's doing it to help his political campaign. That doesn't make it a campaign contribution. He couldn't expense it on his campaign funds to pay off that settlement, and with a non-disclosure agreement. And that's, again, the problem that the DA has here. As you said, it's a lot of rhetoric. It's a lot of smoke. But if you really start boring into it, you start asking people, okay, where's the illegal violation? That is, it becomes pretty flimsy. This case is also weird in another way. I said the U.S. Attorney said, I'm not going to get into all that. It's too long. I hope this helps explain things. There's personal, or what's better to say, non-campaign expenditures and campaign expenditures. If the Trump organization, his lawyers, his accountants, Trump, he'd pay this out of the campaign, it would be a federal offense. An illegal corporate contribution that wasn't reported. But they didn't. They put it down as a legal expense on their business ledgers for the whole world to see. They didn't conceal anything. As a non-disclosure agreement. There is no federal campaign law issue. That's why this Judge Merchan does not want Bradley Smith, Professor Smith, former chairman of the Federal Election Commission, testifying. Because he would shoot a big torpedo in the side of this case and once for all sink it. And I encourage my brothers and sisters at Fox, play it so your audience understands it.